Yes, good afternoon to everybody. Welcome to the class, students of LLB 3YDC, third semester, that is the second year, first semester, whether I could use the word. I'm sure that you are hearing me. So, for my confirmation that you can say it, see, read what I posted on the screen. Anyone can unmute and you the answer to my question. Yes.
Yes,
Uh,
sir.
Very good, very good. That is a good spirit. That is a good afternoon to everybody. The students are will be 3 by DC that I put it over there. And if you happen to see the syllabus is concerned, and because we cover the meaning and concept of property, kinds of property, transfer property, transferable, non-transferable property, that is the section 6, and who can transfer, competent to transfer, then the option of transfer, that is about the section 8 of the Transfer Property Act. Then in the today class that we will see that what is the mode of transfer. The mode of transfer that we have to see, then later on, one after another that we will deal it. So I need not to say what would be the next topic. So today topic is, yes,
Mode of transfer.
very good. So now I will see that come to the point of the mode of transfer. Then I will show you directly the thing which is there on the screen. I'm sure that you could see the screen, isn't it? Is
Yes,
it
sir.
visible screen?
Yes, sir.
Okay, can I magnify it or it's enough?
Enough, sir.
Okay, so yes, now we will see that if the mode of transfer is concerned, the Transfer of Property Act 1882 is an Indian legislation dealing with provisions relating to the transfer of property in India. Yes, whatever the transfer of property would be there, this act will be applicable. And then its main arena is to define what is the constitute the property and the conditions thereof. So accordingly, the term transfer of property may be defined as an act by which one uh, person or conveys the party to one another person or to the group of the person or an individual or juristic person or anyone. And such transfer need not be necessarily a present transaction, it can be a future transaction as well. Moreover, this act not only extended to natural person but also artificial persons, as we have seen in the earlier process. That is, the artificial person is said to be the juristic personality, like companies, association of bodies of individuals, whether corporate or incorporated, doesn't matter. The important consideration here is that what kind of the property are covered under the Transfer of Property Act 1882. There are two broad category of the property which is as under. One is the immobile property, another is the movable property. Of course, we can also say the tangible property or intangible property also. Yeah, in the immovable property is concerned, in layman's language, an immovable property is the one which cannot be conveyed physically from one person to another. However, if we study the provision of the Act, Section 3 defines immovable property as the one that excludes the standing timber, growing crops, and grass. These are the things excluded: the standing timber, growing crops, and the grass. Further, Section 4 of the Act also provides that immovable property includes land, benefits arising out of the land, and things permanently attached to the earth, that what you studied when you were studying the movable and immovable property. Then also we can include the tangible and intangible property also there. So now come to the mobile property is concerned, it is very easy to know. On the other hand, the term mobile property is not defined anywhere in the act, and the meaning of the mobile property is inferred in the section 3 of the act. According to this section, standing timber, growing crops, and grass constitute a immobile property. Then, sorry, it is constitute there is a standing timber and growing crops and grass constitutes, except that one, we can say the movable property. Similarly, as per the section 2(9) of the Registration Act 1908 also provides that standing timber, growing crops, grass, fruits, and trees and property. Then property of just a minute, because it's calling, I cannot now lift it. Yes, coming to the point is that Section 2(9) of the Regular Registration Act 1908 also provides that standing timber, growing crops, grass, fruits, and trees and property of every description except immobile property. So these are things, even fruits as a mobile property once it is severed. Then the trees also a mobile property once you cut down, that's called standing timber. And the grass, the growing grass also once it is severed, it becomes a mobile property. Unless until it is attached to the permanently to the earth, then we can say it's a mobile property. So, broadly speaking, in this Act mainly deals with the immobile property. However, there are some provisions dealing with the mobile property also. Now, the important question that has to be answered is that property law deals with what kind of the properties and what are the modes of the transfer under this act. How a transfer will take place, we will see under this modes of transfer. The act provides that can be transfer of the property via two means. Number one, by act of the parties. Number two, by operation of law. But by operation of law, we cannot study in the law transfer of property, but we will study only the by act of the parties only. So here the act does not apply in case of the transfer by operation of law. Transfer of property act only applies to the by the act of the parties only. Transfer by the operation of the law are governed by the personal laws. For example, Hindu and Muslim law of the will and inheritance by order of the court under civil procedure code, that is the operation of the law, to constitute a valid transfer under this act, certain conditions are to be satisfied, which are under. Number one, it is rightly stipulated in section 5 of this act. Transfer of property means an act in which a living party conveys property in present or in future to one or other living person or to himself and one or more things living person. So the requirement of the section 5 are to be satisfied in order to constitute the transfer under this act. Then what is not transferable is clearly said in the section 6. Then come to the requirements of the section 6 as to what kind of the properties can be transferred under this act to be met. Then the various essential of the valid transfers are to be satisfied are stipulated under 7 of this act, like the parties must be competent to contract. That is the age of majority, soundness of mind, authority to transfer, no other disqualification on the part of the part of the parties, etc. So after the satisfaction of the requirement, either the modes of the transaction, that is section 9 of this act, may be adapted. So what we are studying the section 9, how it can be adapted, what is the mode of the transfer of the property is concerned. So number one, we can give the delivery position, it is enough that the property is transferred. For instance, the mobile property is concerned, yes, suppose your Rolex watch is there, and if you are given to your relative or your brother or sister or son or daughter, any one of the relative, in the form of a gift, by any other means, we can transfer it. There is a merely delivery of position is enough. Yes, any other thing that you would like to ask? Yes, please. Please give me the answer.
Sir,
Delivery of position is enough. Suppose if you want to give the Rolex watch to your relative.
ఇవ్వచ్చు సార్ అంటే అది కాస్ట్లీ.
Yeah, better you give the warranty period also, guarantee period, and this vouchers, that is bills also. If it is given over there, that's well and good. Because that will be a quite good idea to deliver the things. Merely giving the, of course, deliver a position also and a point over there. But if you have the papers also, if suppose something goes wrong with the wristwatch, then you can show to the showroom because the warranty period is there. Okay, that is number one. Number two, registration. So this registration must be done. Genuine registration will be needed for the Rolex watch. Suppose you want to transfer to somebody else. Yes? Give me the answer.
చెయ్యొచ్చేమో సార్ కాస్ట్లీ కదా.
రిజిస్ట్రేషన్ ఏమద్దండి, అది మూవబుల్ ప్రాపర్టీ కదండి. ఇఫ్ యూ గివ్ ద మియర్లీ ద వోచర్స్ ఆర్ ద బిల్స్ అండ్ ద వారంటీ
ఓకే
పీరియడ్,
సార్.
ఇట్ ఇస్ ఎనఫ్. You need not to register that watch. Yes, I am giving this
ఓకే
thing
సార్.
a registration on the point of so and so. Even though Rolex has is a costly watch, no doubt. But when a person, when the things are concerned like the immovable property, that the land or the house, then it should be registered so as to avoid the bigger complications or implications. So this act provides that where the writing is not necessarily under this act, the property may be transferred orally or without writing any deed. So even a oral transfer also, delivery also will be made, but to avoid the legal complications over there, you see, it is a should be a registration is must. So delivery of position, when we come to the delivery of position, whenever you are writing of any deed is not required under this act, such property may be transferred orally, which means transfer of property by delivery of position. In case of the mobile property, this mode of transfer generally adopted, and other kinds of the properties like the sale of immobile property value less than the 100 rupees. This is the old value which is given over there, but now the value is changed. If it is less than the 100 rupees value would be there, then the delivery of position is enough. And month to month tenancy and mortgage by deposit of title deeds it can be concluded that wherever the writing of the deed is not required, the same can be effectuated through an oral transfer. So long that oral transfer are there, suppose a man should be very much strict to his uh, promise. That is a very much important thing in the human being. See, once he promised it, then the promises are there to keep, but the promises are not there to break. That's my point. So, a delivery the position generally they say the value of it is less than 100 rupees would be there, then it can be delivered. That is the thing which is said that a delivery position. When it come to the registration is concerned, yes, whenever there is a need that the transfer must be in writing, then the registration of the same is necessary. So when it is put it in writing, then naturally when you say writing, then the registration is must. This act mentions various transfers that can only be effectuated through the written deed, like a gift of an immovable property or sale of an immovable property exceeding more than 100 rupees value, a sale of a reversion irrespective of the value, leases from 1 year to another year, simple mortgage irrespective of the amount secured, it should be in writing. So in all these cases, oral transfer cannot be effected. Suppose if somebody says, okay, I'm giving this house to you, you take it, and giving the house keys to you. It merely giving the house keys will not be an effective because somebody and who are the legal heirs who transferred this thing. A transferor's legal heirs, you can file a case because it should be registered. That is a very important factor. In such cases, a written deed is necessary, and wherever a written deed is necessary, the registration of the same becomes mandatory. Wherever this is put in writing, then it's a mandatory that it should be registered. The method and the procedure for the registration document and transfer are governed by the Registration Act 1998 in India. And if such properties are transferred without registration, the transaction is held to be null and void. So, whenever you purchase a land, whenever you purchase a house, and especially the immovable property is concerned, then it should be registered, not merely notified, not notaried. No, it should be registered. So, while particularly discussing the transfer of immovable properties, it has to be noticed that it may happen in certain ways only. So, what are the ways would be there? The various ways or modes of transfer of the immovable property are number one. Already we told you. What are the other modes where we can a transfer property can be made? Anyone?
లీజు, సేలు,
Hmm.
ఒకరికొకరు ఎక్స్చేంజ్.
Mm-hmm. Even exchange also comes over there. Okay. Ah. Later on. Yeah, here we will say that yeah, gift will is it not lease, mortgage? These are the things where the
Yes, sir.
transfer of the property could be done. Let me see the sale. Section 54. This is the first mode of the transfer of property. It includes the entering the sale contract between the two parties. Under this contract, the various conditions are valid. Contract as stipulated in the Section 2 of the Indian Contract Act has to be complied. Means whatever the Contract Act says over there, all that essentials are very much essential here for the sale of the goods or property because it is nothing but a contract. So, moreover, if the party values are less than rupees 100, then registration is not mandatory. Of course, it's only theoretical would be there, but now a value of a particular thing also is more than 100 now. It has become so. A registration is not a mandatory if it is less than 100, and however registration necessary for all those properties be transferred. The cost of the more than rupees 100 under the Registration Act 1908. Still, the old rate is there. Still, it is not changed at all regarding the value of the property is concerned. So let us come to the next is mode is mortgage. So in the mortgage section 58 of the Transfer of Property Act is about the mortgage, where that transfer of immovable property can also be take place by means of the mortgage under section 58 clause A, and a Transfer of Property Act. Under this, the mortgagor transfers any of his interest in the specific immovable property to the mortgagee. So a person who does the thing is mortgager, a person who receives and keep it and lend the money is set with the mortgagee. Now, this is done in order to get a loan advanced in the favor of the mortgager. Yes. Out of this loan, a future liability arises, and if the mortgager fails to repay the loan amount, then the property keeps the security with the mortgagee is transferred to him only. Of course, when the kinds of the mortgage, you can see that if you don't pay the loan, then naturally that will be taken by the mortgagee. So that is the way of the mortgage. Also, there is the second mode where the transfer of the property could be undertaken under the Transfer Property Act. So now the third mode is said to be the charge. Yes, Section 100 is a charge is another mode, transfer of immutable property. This is given under the Section 100 of the Transfer of Property Act. A charge is an act by one person to create a secure of a payment of money or another person, and the transaction should not be a mortgage. The latter is said to be have a charge on the property. For instance, or for example, a A inherits a certain properties from his grandmother. I repeat, for example, A inherits a certain property from his grandmother. Okay, he executes an instrument in which he agreed to pay a certain sum of money every year to his sister B out of the rents and profits of the inherited property, and charge by act of the parties is a creation of the power of B. So here is a charge would be created over there on the property which A is receiving from his grandmother to B, but he said that every year that he will give some of the amount from this property, and which he is giving for the rent. From there it will be given to the B, either maybe sister or brother, whoever may be, and that is said to be a charge on him to give that money every year or every month from the rents which is inherited from the grandmother. Of course, she also is having the right for the inheritance, but still the mutation is not done over there. But only that he inherited, and whatever the rent should be there every month that or every year that he is going to give to the sister, and that is the charge. We can say this is one of the mode. With the example, we can know what is charge. Yes. Can anybody will say that what is charge? Did you get the point of charge?
అంటే
Unmute and
తను
give the answer.
చేయవలసిన పని, తను చేసే పని తన నుంచి ఇతరులకి వేరే వాళ్ళకి అప్పచెప్పడం బాధ్యత.
Not Vajata. So he inherited the property from the grandmother, number A. And A, what he did, he executed an instrument, okay, execute instrument JC, in which he agreed to pay a certain sum of money every year to his sister B out of the rents and profits of the inherited property. Charge by the act of the party is created in favor of B. So B is having the charge because she can file a case against the brother, because he executed an instrument to pay every year this much to her survival. Sir, why he has to pay it? The reason is the property is not partitioned among the brother and sister still. So it became a joint property over there. So at that instance, he agreed to pay the B amount, and later on they will think that either to take the entire property with the B after giving some compensation to A, or by giving some compensation or a charge to the B, the entire property can A also will take it out. So that is a different issue, but here charge also a point where the mode of transfer will take place. Next comes the charge can also be created by way of operation of loss. Yes, that for example, A, who is a co-sharer, pays the entire areas of the rent as they required under some provision of the A, and A has a charge by operation of law on the other co-sharer the portion of the property. So in this way also by operation of law, suppose AB have taken 100 rupees from C. So A has taken 50 and B has taken 50. So now the C has to get the 100 rupees because it is a hand loan without interest. So what he did it now? A has given 100 rupees to C, and B, without knowing, he also gave 100 rupees to C. At that instance, how much money is the C got?
200, sir.
200. How much he has given to the C? C given to the A and B? Only 100. That means 100 by mistakenly that he received it. Who? C. 100 from A, 100 from B. So no one can enrich himself at the cost of the others. That means the quasi contracts would be there where the C should have to supposed to return the 50 rupees to the A and 50 rupees to the B. So by operation of the law also there, he is supposed to return it because he should not enrich himself because without knowingly that they have given it. So that is by operation of law also they can make it out. That is the one way or in another way. So now the lease is concerned. Section 105 of the Transfer of Property Act defines lease and an act of the transfer of right to enjoyment. We have the separate chapters in further classes. We will say what is charge, what is sale, what is mortgage, what is lease. Here we are giving the only bird's eye view, means a curtain riser, a glance. So lease is 105 of the Transfer of Property Act defines the lease as an act of the transfer of the right to enjoyment of an immobile property made for a certain period in consideration of the price paid or promised to be paid or money or share or crops, services or any other things of value to be given periodically on specified occasion to the transferor, that is the lessor, by the transferee, that is the lessee. So that is the lease. The lease may be perennial also, because 100 years lease also there. Like I told you, Lakaram Cheru, that is given for the yearly 100 years lease. Yes, come to the immovable property may also be transferred by means of the exchange, gift, and actionable claims. So these are also other modes where the transfer of property could be undertaken in India. So immovable property can also be transferred by operation of laws. Yes, that can also be the another way, but the operation law is not covered by the TP Act, by any other law which will be applicable over there. It will be done either through the quasi contract or by the auction or by any the actionable claim by any other means, but not exactly with the transfer of property. But it is not the subject matter of the Transfer of Property Act when you say it is operation of law. So in the conclusion, what I want to say, so now at least you can get what type of the property and how it can be transferred. Anyone can say now the gist of it. A recap. Yes.
సార్ ఒకసారి తెలుగులో చెప్పండి.
See, mode of transfer of property చెప్పాను.
సార్
ట్రాన్స్ఫర్ ఆఫ్ ప్రాపర్టీలో ఏ విధంగా ఒక ప్రాపర్టీ ఇంకొకరికి వెళ్ళిపోతుంది. మూవబుల్ అయితే ఎట్లా వెళ్తుంది, ఇమ్మూవబుల్ అయితే ఎట్లా వెళ్తుంది. ఎస్, మూవబుల్ అయితే ఒట్టి ఫిజికల్ పొజిషన్ ఇచ్చేస్తే సరిపోతుంది కదండి.
మూవబుల్ అయితే ఓరల్ గా అయితే చెప్పొచ్చు, రిటర్న్ గా అవసరం లేదు.
ఫిజికల్ పొజిషన్ అవసరం లేదా?
ఫిజికల్ అవసరమే సార్.
నెక్స్ట్
ఇమ్మూవబుల్ అయితే సేల్, ఇమ్మూవబుల్ అయితే రిటర్న్ గా ఇవ్వాలి.
సరిపోతుందా ఒట్టి రిటర్న్ ఇచ్చేస్తే?
రిటర్న్ రిజిస్ట్రేషన్ ఉండాలి. లెస్ దాన్ 100 అయితే అవసరం లేదు. 100 కంటే అబౌవ్ అయితే రిజిస్ట్రేషన్ కంపల్సరీ.
ఇప్పుడు మనం యాపిల్ కొంటాను, మోర్ దాన్ 100 తీసుకుంటాను, రిజిస్ట్రేషన్ చేయించుకుంటానా?
అది మూవబుల్ గా సార్,
మూవబుల్ ప్రాపర్టీ కాబట్టి అని చెప్పాలా మీరు.
అవును సార్.
నెక్స్ట్, ఇప్పుడు ఇల్లు ఉన్నది, ఇల్లు తీసుకురా బాబు అంటాం, అయితే సరిపోతుందా?
నో సార్.
సో వాట్ షుడ్ బి డన్?
ఇల్లు రిజిస్ట్రేషన్ చేయించాలి. ఇంటితో పాటు చుట్టూ ఉండేవన్నీ కూడా ఆపరేషన్ ఆఫ్ ట్రాన్స్ఫర్ అంటారు. అవన్నీ కూడా వర్తిస్తాయి సార్. అంటే దాంతో పాటు
there should be a graph, there is a map in the east, west, south, north, area, survey, number, patta, all the other things should be made over there. Whether the clearance from is there or not, municipality or a dues are there or not, whether it is a mortgage or not to somebody else. ఈసీ అంటారు. ఈసీ తీసుకున్నావా అంటారు. ఈసీ అంటే ఏంటిదండి?
ఈసీ అంటే ఏమో సార్.
సో ఈసీ అంటే ఎన్కంబరెన్సెస్ సర్టిఫికేట్, అంటే దాని మీద ఎవరైనా లోన్ ఇచ్చారా, అది మోటర్గేజ్ ఉన్నదా, లీజ్ లో ఉన్నదా, ఏ విధంగా ఉన్నదా, అది ఫ్రీగా ఉన్నదా, దాని ఎన్కంబరెన్సెస్ సర్టిఫికేట్ విల్ బి ఇష్యూడ్ బై ద రిజిస్ట్రేషన్ ఆఫీస్. ఇట్ స్టేటింగ్ దట్ he is the owner of the property and it is not mortgage, there is no any other monetary charges over there in that land or on the house.
ఇది ట్రాన్స్ఫర్ కి ఎలిజిబిలిటీ ఉందా లేదా, సరిగా ఉన్నదా లేదా, ఏమైనా అడ్యూస్ ఉన్నాయా,
అది సంగతి. దాన్ని అంటారు ఈసీ సర్టిఫికేట్. ఈసీ అంటారు ఎన్కంబరెన్సెస్ సర్టిఫికేట్. యూ షుడ్ బి ఇష్యూడ్ విత్ ద రిజిస్ట్రేషన్ ఆఫీస్. ఆఫ్ కోర్స్ అప్లై చేయడం తర్వాత మీ సేవ. సో హౌ యూ ట్రాన్స్ఫర్ ఇట్? ఒక ప్రాపర్టీని ఇంకొక ప్రాపర్టీ ఎన్ని విధాలుగా మనం ట్రాన్స్ఫర్ చేయొచ్చు చెప్పాలా? బై సేల్,
లీజ్, మార్గేజ్, ట్రాన్స్ఫర్,
ట్రాన్స్ఫర్
ఎక్స్చేంజ్
కాదు అది, ఆల్రెడీ దీస్
ఎక్స్చేంజ్
ఆర్ ఆల్ ద ఎక్స్చేంజ్ వి కెన్ సే విల్.
విల్ సార్.
So by all this means we can transfer it the property. కాకపోతే how much the right would be there, it depends upon, suppose lease ఇచ్చినాం అనుకోండి, the ownership will be transferred to in the lease.
ఓనర్షిప్ వెళ్ళదు సార్.
ఏం వెళ్తుంది మళ్ళీ?
ఓన్లీ లీజ్ మాత్రం సార్.
పొజిషన్, ఎంజాయ్మెంట్.
ఓన్లీ పొజిషనే ట్రాన్స్ఫర్ అవుతుంది, ఓనర్షిప్ ట్రాన్స్ఫర్ అవ్వదు.
సపోజ్ లీజ్ పీరియడ్ అయిపోయింది అనుకోండి,
లీజ్ పీరియడ్ అయిపోతే తిరిగి ఓనర్కే వస్తుంది ఆ ప్రాపర్టీ రైట్.
సో ఓనర్ కెన్ రీఎంటర్ the land and he will see that evacuated if the lease period
Yes,
is
sir.
over and if it is not renewed. ఇప్పుడు మోటర్గేజ్ ఉన్నది అనుకోండి, మోటర్గేజ్ చేసిండు, మోటర్గేజ్ చేసిన ప్రాపర్టీని అమ్మచ్చా అండి?
నో సార్.
ఎందుకు అమ్మలేరు? కొనటడు మొత్తం మోటర్గేజ్ లోన్ ప్లస్ ఇంట్రెస్ట్ ఇచ్చేసి అది డిడక్ట్ చేసి మెయిన్ అమౌంట్లోకి వెళ్ళి ఇవ్వచ్చు కదా.
మోర్టగేజ్ ప్రాపర్టీ ఇవన్నీ ఇలాంటి ఏమన్నా ఉంటే ట్రాన్స్ఫర్ చేయకూడదు, ఆల్రెడీ అగ్రిమెంట్ వేరే ఉన్నది కాబట్టి.
ఇప్పుడు వాడు అంటాడు, ఓకే దిస్ ఈస్ ద మోటర్గేజ్ ప్రాపర్టీ, ఓకే ఐ విల్ పే ద మోటర్గేజ్ అమౌంట్ విత్ ద ఇంట్రెస్ట్, దెన్ దట్ అమౌంట్ విల్ బి డిడక్టెడ్ ఫ్రమ్ ద ఒరిజినల్ ప్రైస్ ఆఫ్ ది ప్రాపర్టీ.
నో సార్, నాకు తెలిసి.
See, the point here is, suppose the mortgage property is there and it is known to the purchaser. So, what the purchaser will do it? So, he will take what are the mortgage deeds are there and he will pay the amount and he put it in writing that he doesn't have any right over this property, and that property he can purchase it from the person who is the owner of the property. ఇప్పుడు కుదవబెట్టినాం అనుకోండి, అది కుదవబెట్టిన సపోజ్ బంగారమే, అదే ఇదే గొలుసు అనుకున్నాం, గొలుసు కుదబెట్టుకున్నాం, ఆ గొలుసు కొనదలుచుకున్నవాడు ఏం చెప్తాడు, ఆ కుదబెట్టిన అక్కడికి వెళ్ళి పైసలు ఎత్తి తీసుకొచ్చి మరి వీళ్ళ దగ్గరికి వెళ్ళి తీసుకుంటాడు, అంత పైసలని డిడక్ట్ చేసుకుంటాడు. సేమ్ వే he will clear the everything, then he takes the property.
Okay sir.
So there are modes are there, if any charge is there, if any other thing would be there, if the clearance would be there or not, then only that it can be either formed in the lease or it will be sale or it will be exchange or it will be done in any other manner is concerned. So now the conclusion what I want to say is, before the transfer of any property, it affects if it has to be taken into consideration that what kind of property are transferable. అసలు ఏ ప్రాపర్టీ ట్రాన్స్ఫర్ అవుతుంది, దట్ ఈస్ ఏ వెరీ ఇంపార్టెంట్ ఫ్యాక్టర్. సపోజ్ రోలెక్స్ వాచ్ ట్రాన్స్ఫర్ అవుతుంది అనుకుందాం, దానికి రిజిస్ట్రేషన్ ఆఫీస్కి పోయి రిజిస్ట్రేషన్ చేసుకునే అవసరం ఏం లేదు, జస్ట్ గివ్ ద రోలెక్స్ వాచ్ టు హిమ్ అండ్ గివ్ ద వారంటీ పీరియడ్ అండ్ వాట్ ఎవర్ ద receipts are there, you can give it. On the receipt, can you change the name?
No sir.
అదే మోటార్ బైక్ కొన్నారు అనుకోండి, then you have to change your name. మోటార్ బైక్, కార్ కొన్నాం అనుకోండి, అందులో మళ్ళీ పేరు మార్చేయాలా? అదర్వైజ్ ద ఓనర్ వానికి వెళ్ళిపోతుంది మార్చకపోతే. ఇప్పుడు ఎవడైనా ఈ సపోజ్ ఇఫ్ ఇట్ ఈస్ కాట్ ఓవర్ దేర్ వే ద సిగ్నల్ జంప్ ఈస్ దేర్, సో దెన్ ద ఈ చలాన్ విల్ కమ్ టు ద యువర్ హౌస్, ఓనర్స్ హౌస్, even though that is used by some other person. So there it will be changed, the name should be changed. So ఇందులో ఏమైతుంది, సెక్షన్ 6 of the action explains all those properties which cannot be transferred. ఇవి ట్రాన్స్ఫర్డ్ కాలేదు, మనం సెక్షన్ 6 లో చేద్దాము. దట్ ఈస్ వాట్ ఈస్ దట్, లైక్ రైట్ ఆఫ్ రీఎంట్రీ, ఇట్ కెనాట్ బి ట్రాన్స్ఫర్డ్. స్పెస్ సక్సెషన్ ఈస్ apparent what is inheritance, it cannot be transferred. And future maintenance, it cannot be transferred. Transfers opposed to the nature of interest, it cannot be transferred. So we read at least 10 things which cannot be transferred under section 6, and this can be inferred from various case laws, such as in one of the case law, it was held that the appellant purchased the rights expectant upon the termination of the surviving widow's right from the respondents and further and there was a compromise between the widow and the respondent, as a result of which the respondents got certain properties. Thus it was held in the case the compromise is void and cannot be transferred. So whenever the compromise would be there, sometimes it cannot be transferred. So that is if it disputed. That depends upon the nature of the property and how the situation it will be there. So on that respect, we can say whether the transfer is effective, whether the transfer is not effective. Similarly, in another case law, a charge cannot be transferred because it is a right which is a part of the property. So a charge also cannot be transferred over there. A compromise cannot be transferred. This is another point. And easement cannot be transferred. So right of the way cannot be given to a third person because right of the way goes with the property. Right of light goes with the property. Right of air goes with the property. So it is isolated. One thing cannot be transferred. So easement cannot be transferred because there are the rights of interest arising from the land which is a part of the property but cannot be transferred. Like the family arrangement may be transferred. So a will cannot be transferred because it does not operate by the act of the parties. Can you transfer the will?
No,
For
sir.
one person to answer no. First he will get it. Later he wants to give, he can give it to anybody.
Yes, sir.
So action sale cannot be transferred because property is in possession of another. So certain things which cannot be transferred also we can say, and we also said a party cannot be competent. A party cannot be a transferee under section 136 of the Transfer of Property Act. Who are they?
కాంపిటెంట్ కాంట్రాక్ట్ అంటే 18 అబవ్ ఉండాలి, సౌండ్ మైండ్ అయి ఉండాలి.
I repeat.
డిస్క్వాలిఫై
I repeat.
సార్.
A transferee cannot be competent to take the property under section 136 of the Transfer of Property Act. Who are they? You gave the answer one time when I asked the same question, but I don't know why you are not giving the answer to this one. Judges?
డిస్క్వాలిఫైడ్ లా అంటే లీగల్లీ డిస్క్వాలిఫైడ్. జడ్జెస్
Yes, judges,
లీగల్ ఆఫీసర్స్,
legal officers,
ఆఫీసర్స్,
legal staff cannot purchase the property which is actioned in the auction or actionable crimes. They are incompetent. The reason is they are attached to this property or vested interest would be there. So that's why they cannot supposed to purchase the land or any other thing which is actionable. So therefore it is concluded that before considering the question of the mode of transfer, so the mode of transfer, it is to be first ascertained that what kind of the property can be transferred. If the property is a transferable property, the same can be transferred via using the different modes of transfer as discussed above. Suppose father wants to transfer his property to the son or daughter. So can he sell the property to the daughter or son? Then what is the mode of transferring where there is a love and affection is there? Yes.
సార్.
Gift.
గిఫ్ట్ ట్రాన్స్ఫర్ చేయొచ్చు.
We can transfer by the gift. We can transfer by the sale. Yes, go on.
No,
we can
sir.
transfer by the lease. We can transfer with the mortgage. We can transfer by the exchange.
No, no, sir. సార్ గిఫ్ట్ ట్రాన్స్ఫర్ చేయదు.
ఇప్పుడు ప్రాపర్టీ ట్రాన్స్ఫర్ చేయాలంటారు, గిఫ్ట్ ట్రాన్స్ఫర్ చేయాలంట. విల్ అంటే నేను
ఓకే సార్.
ఐ సెడ్ ప్రాపర్టీ త్రూ ద
ప్రాపర్టీ వన్ పర్సన్ టు అనదర్ పర్సన్ ట్రాన్స్ఫర్ అవుతుంది.
ద మోడ్ విల్ తోని ట్రాన్స్ఫర్ చేయొచ్చు, గిఫ్ట్ తోని ట్రాన్స్ఫర్ చేయొచ్చు, లీజ్ తోని ట్రాన్స్ఫర్ చేయొచ్చు, మోటార్గేజ్ తోని ట్రాన్స్ఫర్ చేయొచ్చు, దెన్ సేల్ తోని ట్రాన్స్ఫర్ చేయొచ్చు. సో దీస్ ఆర్ ఆల్ ద మోడ్స్ ఆఫ్ ఇట్ వేర్ దే ట్రాన్స్ఫర్. మరి ఏ ప్రాపర్టీని చేయాలి ట్రాన్స్ఫర్? విచ్ ఈస్ నాట్ covered under the section 6. ఎందుకంటే సెక్షన్ 6 లో ఆల్ ప్రాపర్టీస్ కెన్ బి ట్రాన్స్ఫర్డ్ అన్నాడు.
ఎస్ సార్.
కానీ
సబ్సెక్షన్స్ మినహాయించి
కానీ మళ్ళీ అక్కడ ఇచ్చిండు ఏ బి సి డి డబల్ డి స్మాల్ డి ఈ ఎఫ్ జి హెచ్ ఐ వరకు ఇచ్చాడు. సో
ఎస్ సార్.
దోస్ ఆర్ ద థింగ్స్ వీ కెనాట్ లైక్ స్టైఫండ్స్ ఉన్నాయి. స్టైఫండ్స్ వీ కెనాట్ ట్రాన్స్ఫర్ ఇట్.
ఎస్ సార్.
ఎయిర్
నో
ఉన్నది,
సార్.
లైట్ ఉన్నది, నేచురల్
Cannot transfer.
రిసోర్సెస్ ఉన్నాయి, ఇట్ కెనాట్ బి ట్రాన్స్ఫర్డ్. ఆర్ సచ్ రైట్స్ విచ్ ఈస్ ఇల్లీగల్ ఆర్ పాలసీ అగేన్స్ట్ ద పాలసీ that cannot be transferred, and a incompetency is there because of the section 136, he cannot be transferred. So those are the things where is clearly mentioned in those things. So whenever a particular thing is there, which are the things to be transferred, which are the things not to be transferred, that you might have seen it, that is a very much good for that one. So one can understand what are the things to be transferred, what are the not things to be not transferred. This is the thing that we will make it out. So what I want to say is, yes, those are the modes of the transfer. The same thing here again, it is given modes of transfer of property. There are transfer of the property in India by sale. I have given the elements of sale I mentioned. Then by register I made, by delivery of position we made, then the mortgage we made, and later on lease by we said. Then the exchange, when two persons transfer the ownership of one thing for the ownership of the other, it called the exchange. And exchange is dealt with the chapter 6 of the Transfer of Property Act 1882. Then in the form of gift also we can transfer property, where the donor and donee is there. We have separate chapter. We have to deal each mode of the transfer, separate chapter. Gift, separate chapter. Exchange, separate chapter. Lease, separate chapter. Of course, for pledge we don't say separate chapter, but for the movable property is transferred. The security collateral, it is called the pledge. Suppose Rolex watch ni kudobettu anukondi. So can I say that I mortgage my Rolex watch?
కుదరపెట్టొచ్చు సార్.
Movable property ni pledge అంటారు. You read what is there given in the mortgage, you read.
మోర్టగేజ్ టు మోర్టగేజ్ ఏ ప్రాపర్టీ అదేనా సార్?
Read.
Mortgage to mortgage a property is to transfer an interest in a property to secure a payment or as a security or collateral against payment. The mortgage of an immobile property is governed by chapter 6 of the Transfer of Property
6
Act
అది 6 అండి అది
4 sir. Sorry sir. Chapter 4 of the Transfer of Property Act 1882. Sir, చదవనా సార్ ఇంకా? When a movable property is transferred as a security or collateral, it is called pledge. Although in when a movable property is transferred as a security,
any movable property is transferred as a security or collateral, it is called a pledge. దాన్ని మోర్టగేజ్ అనరు. మోర్టగేజ్ దేనంటారు? ఇమ్మూవబుల్ ప్రాపర్టీని అంటారు.
ఓకే సార్.
మూవబుల్ ప్రాపర్టీని ఏమంటారు?
ప్లెడ్జ్ అంటారు.
ప్లెడ్జ్ అంటారు. ఇప్పుడు తెలుసా ప్లెడ్జ్ కి మోర్టగేజ్ కి డిఫరెన్స్?
మూవబుల్ ప్రాపర్టీ ఉంటేనేమో ప్లెడ్జ్ అంటారు, ఇమ్మూవబుల్ అయితేనేమో మోర్టగేజ్ అంటారు.
Although in a mortgage the possession of the property remains with the mortgager, it can be said to be the loosely have a similarity with the mortgage of an immobile property. The pledge of the movable property is governed by the chapter 9 of the Indian Contract Act 1872. Kabatti manam pledge chadavamu Transfer of Property Act lo. So lease, as you attend, is already, exchange we did it, and gift we did it. So these are the different types of the modes where we can transfer our property. Says, any other doubt is there? Yes. Sayyid Rasul, unmute and give me the answer. Because you are a silent spectator today. You did not give any reply to my question. So try to participate it. When you participate, you learn it. Yes, say.
Area cover of gone, sir.
Pardon?
Power gone, sir.
But I could see you now. I could hear your voice.
Sir, yes, sir.
Can you say what is the pledge and what is the mortgage? If you know it, you say. If you don't know it, you pass on, you say.
Pass, sir.
Yes, Jai Bharati, give me the.
సార్ మూబుల్ దానికి ప్లెడ్జ్ సార్, ఇమ్మూబుల్ దానికి మోర్టగేజ్ సార్.
అదే ఇంగ్లీష్ లో చెప్పండి, కొంచెం ట్రై చేయండి.
ఇమ్మూబుల్ ప్రాపర్టీ, సారీ సార్.
అదే ఎప్పుడైనా ట్రై. ఇఫ్ యు సే లైక్ ఇఫ్ యు డోంట్ ట్రై యు డోంట్ లెర్న్. ట్రై ఇట్.
ఎస్ సార్.
ట్రై ఇట్.
ఇమ్మూబుల్, సారీ సార్.
What sorry? Immovable property will say mortgage. Movable property will say pledge. చెప్పండి.
ఓకే సార్.
Say.
Movable property we say pledge.
Okay.
Immovable property we say mortgage.
Yes. If immovable property is mortgage, we will say it is a mortgage. If a movable property is mortgage, we will say it is a pledge. And కొంచెం nice గా. Or if a movable property is kept as a security, we can say pledge. If immovable property for the security for the loan, we will say mortgage. Try, unless until try, that you cannot learn it. So either may be the beginning, it may be the wrong, doesn't matter. But after sometimes you will become a expert. దానికి అందుకోసం అంట తినగ తినగ వేపాకు
తీయనుండు.
ఎట్లుంటదండి? వేపాకు ఎప్పుడైనా తీయగుంటదా అంటే అలవాటు అయిపోతుంది అన్నట్టు అర్థం అక్కడ. So any other doubt? Sayyid Rasul,
sir.
can you tell me what is the difference between a pledge and a mortgage?
సార్ మా ఏరియాలో పవర్ పోయింది సార్, ఇప్పుడే సార్ వచ్చింది, అందుకోసం యాక్టివ్ అయింది సార్.
మళ్ళీ ఇప్పుడు
యూట్యూబ్ చూసాను సార్.
No, did you hear me what I said?
సార్
ఇప్పుడు నేను చెప్పింది అర్థం విన్నారా మీరు?
వింటున్నా సార్.
జయ భారతి చెప్పింది విన్నారా?
సార్ ఇక్కడ కాదు సార్, పవర్ వస్తుంది పోతుంది
అరే నాయన, నీ మాట నేను వింటానా, నా మాట నువ్వు వింటానా, మరి ఇంకా పవర్ సంగతి ఇక్కడికి వచ్చింది నాయన ఇందులో.
సార్ ఇప్పుడే కరెక్ట్ అయింది సార్, మళ్ళీ వస్తుంది పోతుంది సార్. ఇది
వస్తుంది పోతుందా? చెప్పని. ఓకే, మోటార్ గేజ్ స్పెల్లింగ్ చెప్పిన ఆయన చూసేనా చెప్పు కనీసం. మోటార్ గేజ్ చూసేనా చెప్పు స్పెల్లింగ్.
సార్ మోటార్ గేజ్ సార్. హలో,
చెప్పు చెప్పు వింటున్నా.
MORTGAGE.
వెరీ గుడ్. ప్లెడ్జ్ చెప్పు.
PLEDGE pledge.
Okay, very much thank you. It is a clapping to you, and we'll see you tomorrow at the 3:15. Try to inform the other people. Even one person also there. My teaching is there as I promised to you. So with this, I would like to close down the thing, and we'll meet tomorrow at the 3:15 again, and we'll deal with the next topic which we have not covered. Yes.